And well, we also have we're gonna have a recorded version of this, so you can perhaps see it later. Um, Today's agenda is we're gonna try to recap what we discussed in the last orientation session very quickly, just a refresher, just a reminder what we discussed, and then we're gonna do another sort of review of the fee assessment process and calculations. These are again refreshment stuff, and we will then talk about what are the different elements of a fee calculations and eligible activities, eligible improvements, and I want to stress this that all of these are uh, just for information, for background information, particularly for the board members to understand the concept rather than understanding or providing them with detailed engineering analysis. No, it's just a primarily is just to make the board and the staff uh, familiar with different terms and definitions and the processes. We will also discuss alternative fee determination. This is mostly is used for those cases that a fee payer or a developer may not agree with the decision of the staff of the town, and then they may want to propose a their own alternative, or it may be the case that we may not have a specific use, or they may think that their proposal is very unique, and they're willing to go through the developing this alternative fee estimation and provide that. So we'll discuss the elements of it, so the board will be familiar with it. Um, we are also talking about the appeal of decisions. That is primarily that's what the review board does or is an appeal entity to review these cases and make a judgment. The uh, Another item that we will discuss is the board authorities and responsibilities. I've asked Adam to lead this part of the effort, and he is he's in court this morning, and I understand, however, he will be out of that court meeting, and he will join us at the end of our presentation and discuss it. If he does not get in today, we will revisit this issue next meeting, which is going to be our last meeting. But nonetheless, the statute is included in this presentation, and I can read it. Generally, we discussed a little bit of it last time, and we can. I'm pretty sure if Adam comes in, he's going to discuss it a little bit more, and the board members can also ask questions. Um, we will also set the next meeting for the next or the last meeting for this orientation sessions. I'm going to start with a sort of recap, as I mentioned, of some of the concepts we discussed last time. And by the way, as I said, Adam is going to join us, and hopefully will contribute throughout this process. And as you know, Denny is also here, and he is going to also contribute in some of the sort of scenarios that he's basically involved on a daily basis, and I think that would be very helpful in getting a sort of broad understanding of the process and some of the issues. Um, let's start with a recap. Again, we discussed this. What is an impact fee? And that is charges or assessment that are imposed against a development in order to generate revenues or recouping the cost of capital improvements for attributed to that development. So a development comes in, they have some impact, and the charge is imposed on them for that impact on a proportional basis. Indiana has its own definition of the impact fee, and that the statute calls it as it's a monetary charge imposed on new development by a unit to defray or mitigate the capital cost of infrastructure that is required by or necessitated by or needed to serve new development. So in Indiana statute basically connects any type of impact with that development to defray those costs. Impact fee basics. Again, this is what we discuss. It is based on the land use. It applies to all kinds of development, and what we call development here is generally means different land uses, and it is a formula-based calculation, and based on primarily the land use type and the level of trip generations. We're going to discuss a little bit more on trip generations, or Denny is going to do it, and but it is land use based. It is based on the number of trips that those land uses will generate on a typical day. It is on a pro rata basis. In other words, it's a proportional cost of that development as a part of the overall system or the impact on overall system. So that basic assumption is there that new developments should only pay for their impacts on a prorated basis. And it is typically collected at the time of building permit. There are several principles involved in an impact fee, and number one is that the improvements that are implemented as a result of this fee, they must address the growth, and it has to be for specific improvements and a specific assessment area. In the case of St. John, assessment area is the whole town. In the case of specific improvements, all of the studies that the town has done, as well as the zone impact fee, a study that we did earlier, those identify the specific improvements.
Tagi, let me ask you a question while we're on this point, and I just want to reiterate from my own knowledge and maybe everybody else's. This says for specific improvements for specific assessment area. The TIF district itself is a complete considered assessment area. So say a development is in the undeveloped portion of the TIF district, or do we will expand the TIF district as needed going forward, and that may occur in this time period. Does that TIF district that we expand to, will that fall into this, or is that going to be excluded going forward? And in other words, we have to wait for the next 5-year assessment or evaluation or study before we can include the new portion in the actual spending of the money?
Good question. Yeah, when we discussed this, you recall that we discussed establishing a sort of what we call the subzones or sub area or benefit area, and it was a decision of and one of those benefit area could have been, let's say, the TIF districts, but it was a decision of the advisory board to select the service area, the whole corporate boundaries. So what you do in the TIF district, whether it is expanded or not, it is covered, and it has no impact on the impact fee, the amount of it, or how it is charged.
So regardless of how much annexation could take place in the next 4 years, 4.5 years, regardless of how far we may annex, and who knows what the future holds for the town, whether it's us or the next group. Therefore, it's all going to be included, border to border, regardless of where it goes and what our study determined initially.
Yeah, the personnel manual and by your practice, the when the service area is established, in that includes any future impact, any future annexation.
That's all I
As
wanted.
you annex, as you annex areas, those areas are automatically incorporated.
I just wanted to verify that, not only for my own edification, but the rest of the group as well, so that there is no limitation as to new projects we may have up that aren't in the study or weren't in the initial impact fee study. Okay.
Yes, that is my understanding of the law.
Thank you.
You're welcome. So the fee is a proportional. One of those other principles is the fee is proportional to the impact. In other words, the fee equals that proportional share. Some of these things you notice that I'm repeating myself, but there are some value to that. And the next item is brings out equity principle, and it may sound like it is proportional share of is the same as the bullet above, but it is not. It is the towns or the municipalities and the impact fee concept requires that if there are other investment are made in facility improvement and capital improvement, and if those funds are paid by the taxpayers, and that includes future taxpayers, then that has to be considered. So not the taxpayers are charged twice. A good example that I always use is if the town issues a bond and for facility improvement, for some type of road improvement, it is assumed or presumed that those bonds will be paid by these future tenants or future occupiers of new development, and they are paying into that. So that equity principle comes in, and that is one of the other principles of this. The other one is that it is basically this is nationwide, and that is that developers should have the right to do the improvements and collect that fee against or collect a credit against the fee. So that is and in Indiana, that's absolutely permitted and required, or at the option of the developer, it is there. One of the other principle is that uh, generally any type of impact fee should maintain a a certain level of existing level of service, and that is, if you're providing a amount of service today, or the amount of service today, you cannot expect new development to pay an a amount of service today. So that is another principle. When we did this study, and we selected or the town, I should say, selected a level D, and all of the calculations is on that basis of level D service. And again, this is, you may recall last time Denny talked about what is level D, that basically the level of transportation, a good example of the amount of congestion on a road. We talked about legal authorities last time. Again, at all levels, local, state, and federal government, they all have jurisdiction over the impact fee, because it is a land use activity. And in all of these, there are two sort of tests that comes into play, and what is what's called a rational nexus and a rough proportionality. And it these principles basically say that there has to be a reasonable connection between the need for facilities and the new development. Other words, the new development, the fee has to have some connection with the new development or the amount of new development. The also it is the fee payers should see some type of benefit from those fees. In other words, those fees should go into some type of improvements, and that's why it is the town has to set up a specific account for it, and that account has to be, or fund has to be spent specifically for road improvement or road expansions. And again, the another legal concept or test is it fair share? The fair share goes back to proportionality, and that is that's also in several court cases. And the last, that's mostly in Indiana, that the Indiana statute indicates that this all of these proportionate share and benefits, all of those has to be a reasonable estimate, and then that's what the calculations is all considered. So we have done the studies, and the last the zone improvement plan established the fee, and the fee is $338.09 per trip, and this fee went into the ordinance that the town approved, and you've seen the table on the bottom that basically shows the fee, the advisory committee's recommendation for a gradual fee rate at different level over the next 5 years, with the 100% fee being on the years 4 and 5. Any questions so far? Anybody from particularly the board members that are on here? Because I'm going to move on to next. No, great. You have seen this. I'm going to bring in Denny, and he's going to go very quickly over these. You have seen it again. This is a refresher on what is trip generations and how we address them. Denny, you want to chime in?
Okay. Trip. The primary uh, way we charge the fee is by the amount of traffic that is on the road, and we start with a concept of a trip. And a trip is either a one-way movement into or a one-way movement out of a development. And this can be determined on the peak hour. It can be in the morning. It can be determined in the afternoon, or it can be determined on the basis of a whole day. And it's basically a relationship between the various land uses and the number of trips that are generated for those land use. Next slide, Tuggy. Once we determine the number of trips, then those trips are can be broken down into some various categories. The primary trip is the trip that you make to the development. For instance, if you want to go to a grocery store and you drive to the grocery store and you pick up your loaf of bread and you drive home, that's called a primary trip. A pass-by trip is when you're on your way to pick up the kids at school and you stop at the grocery store to pick up your loaf of bread and then continue on your way. A diverted trip is that you're on your way to, say, Cherville, and instead of going directly to Cherville, for whatever your purpose is, you drop down to Target and pick up your loaf of bread, and then you go on your way back to the original purpose of your trip. And then there are trips that occur when land uses are grouped, and there may be one trip into the driveway, but you may visit multiple destinations within that group of buildings. For instance, you might go over to Target, but you might also then use the access road internally to go to McDonald's or something like that. So those are the types of trips that we then categorized. The next slide gives you a little bit of more visual on that, but I won't dwell on that too much. So the next slide, Tuggy.
Yeah, the purpose of this wasn't to talk about this, just for you to get familiarized with these concepts, and because you will hear it from as you go through different evaluation or different requests. Go ahead, Denny.
Okay. So our primary resource document for this is the ITE Trip Generation Manual. And within that manual, there are various different variables that can be used. There also are subtle differences in the descriptions. And so you want to be very careful this is for staff, not so much for the review board, but in making sure that you pick the description and the land use code that most properly fits the proposed development. And then you select a variable. Now, our study was done, the original impact fee study was done on the basis of 1,000 square foot for most things other than residential. But there are other variables. For instance, in hotels, there are numbers of beds that can be used. So the developers may come back with alternative ways to compute the trip generation, and those alternative ways are valid, and they are permitted within the ITE manual. So the biggest thing is, and we'll touch on this in the next slide, is that we have to understand how the data was collected. We need to understand how many sites were used. There'll be some reductions due to pass-by and internal. And the biggest thing is this is not going to be all 100% cut and dry. There's going to be a little bit of variation that will occur. And just understand that these are estimates, and they are subject to some variability. So just keep all those things in mind. Next slide, Taki. And so the next step in the process, if the developer doesn't believe that what the town has provided to him for trip generation and therefore fee is appropriate, or in the case of perhaps some land use that we don't have a trip generation for, he can do an independent study. and this is called the independent fee study. And so he can do this, and some of the things that can be involved in this is, of course, the land use, the locations, the intersections that are involved, the traffic, the times of day, the growth in the traffic, and perhaps the crash history. These are all things that could go into it, but you probably won't see all of them on every one. And we don't think there's going to be many independent studies. The output is the congestion. You want to know that you're maintaining a level of service D, queue lengths, and most importantly, forecasted trips by the development, and then congestion, and then alternatives, and then you come up with the fee calculation. Next slide. You want to take over here, Doctor?
Yeah. You, Bob, the most, particularly the board members, they're going to deal with two concepts. One is, or two types of process work. One is relates to the credit that developers will ask for, and the other one is dealing with the appeals. And the credits are based on the amount of property or improvements paid by a new development for that same type of facilities, and incorporated into the impact fee schedule. And this is the credit can be provided by a developer as a right. They can request that. They can submit it, and often the improvements that they determine is basically removing some of the work that the town may have to do. So for that reason, they get credit. In that is mostly on a general project based credit. There is another term that is often used for improvements that a developer may do that may be beyond the needs of a development, or it could be offsite, and it could be somewhere not necessarily immediately in that proposed site. A good example, a developer may propose that they're going to do let's say a stoplight or on the block, next block, to control some of the traffic. So that is called the sort of offset cost or offset credit, and it is acceptable way of providing credit. Credits are typically proposed by the developer, then reviewed by the town, and the town will have to agree to that. And so that is one concept. The other concept is a lot of times the board may face this. That what if can you give me a waiver? Can you is my development exempt? And we have had several case laws, and that is basically not the case. All new development have to pay their own proportionate share, and therefore no development is exempt. We've seen this in some other communities, primarily for economic development reasons, that the town decide that they are going to pay some or provide some relief, but that is a town decision, and the town has to basically reimburse the impact fee fund for the amount of relief that they provide for that development.
Tony,
Yes.
Excuse me, does this become a town council exemption, or does it still belong to the administrative decision of which the town is a part? But how does that actually come about?
The cases that I am aware of, the instances that I am aware of, has been that, let's say, Economic Development Commission makes a recommendation and then pays portion of the fees that a development is required to pay, and that portion of the fee includes the impact fee, and whatever process that the town has, that municipality has, for approving of this relief, that is, I assume, that prevails. I think in the case of St. John, the town council will have to approve that. Did I answer your question, Brian?
Yeah, more or less.
Okay, great. So there is a process, and the statute also specifically establishes to some degree what that process for credit application is. And the statute does allow specifically that the fee payer or a developer may request the credit against the impact fee for any contributions, payment, construction of activities that improve the system, or also can for any type of land dedication or conveyance of the land. So that is clear, and it typically, and we will discuss in the process a little bit more. Typically, it is done at the time of permit application. In other words, a developer comes in and a fee is determined, and the developer says, "These are my plans, and I want to have credit for these improvements." It is we gotta understand that is not necessarily automatic for the town to approve it. There is the whole credit application process is an administrative decision, is a town decision, and eventually it is the town council decision to approve a credit or not to approve a credit, and it is the responsibility of the town to determine what improvements are needed and meets the townwide objectives. And if
excuse me, I want to stay on these points as they come up. I keep interrupting.
Go ahead. No, that's fine.
This is for both you and Denny. In this particular case, if the town council gets into the mix, basically the approval between the town council and the committee, in other words, they're separate entities and the committee itself has a lot of authority. Are you aware of anywhere where there's been, Denny, this goes with you too, is there anywhere you're acquainted with any conflict between, let's say, an economic deal made by the councils versus the administrative group or the committee, the advisory committee? Has there ever been a disagreement and or situations where there was a disagreement about the value or the amount of the credit or the giving them the credit in the first place? Are you with me?
Yeah, Danny, feel free to chime in. We had a we had a very long
I'm
conversation
not aware
with
of
Adam.
anything.
I wish he was here, about that sort of messiness that you brought up that could be generated. And this is my understanding. We get to it a little bit later on in the sort of the process chart. It is a process. It is the developer can propose, the town can review it, accept it, or reject it. And that acceptance or rejection would be something that the town council will be involved. In other words, upon recommendation of a town officials, in this case, either the building and planning administrator or the town engineer, uh, will make a decision to approve it or not approve it, and then the developer has a option of appeal that decision. Let's assume that you reject, the town council rejects a an application for credit, and or approves an application for credit for certain amount less than what the developer wants, and then that decision can be appealed to the review board. And the way I understand it, the review board has the final say. In other words, they could accept the town council's decision or modify it, change it, expand it, reduce it. They have full authority uh, as the town council, and their decision would be final. Denny, you want to add anything to it?
Nope.
Okay, great. Did I answer your question, Brian?
Yes, sir.
Okay, great. Um, and all of these things in the credit application, the developer is required to submit an improvement plan. And that's basically an engineering uh, studies and plans and the cost estimates, all of that. The the manual, the administrative manual outlines what needs to go in that improvement plan in detail, but it is they have to provide that to the town. There are several criterias that the town could use, or the committee could use as they evaluate these credit applications. And one of those criteria would be that the a credit cannot be more than what is the total impact fee, and the a developer could uh, spend or invest more in a project, but the maximum allowed is the amount of credit, the amount of fee, and and one other criteria would be that an impact fee credit may not be transferred from one development to another. Let's say a developer has two different subdivision in different parts of town and has got some credit approved for one. He cannot take that credit and use it for another subdivision. And these criteria is as the review board goes through this, as the town goes through these developments, I anticipate that at some point in the future you're going to more refine it based on the cases that you have or you have seen. So these are some of these criteria can be changed or modified in the future. Um, the amount of credit has to be basically based on the actual cost and the value of the land, if there is a value, and also in most cases the manual does require that a credit agreement to be developed as a basis for approval of the final credit, and that credit agreement typically it is approved. Eventually, it is approved or adopted by the town council. Another sort of criteria that is in we have put in there in the administrative manual, and that relates to the land dedications. And the several criteria is there. I have listed a few of them here. I think four of them. One of those criteria has to be that the land should result in a becoming a part of the St. John Road system. In other words, it has that sort of land has to benefit the system as it has been outlined in different documents, and for example, in comprehensive plan or capital improvement plan or the zone improvement plan. So that has to be part of that system. Also the land has to be suitable for future transportation facilities, for land dedications. Don't give the town, a wetland area and say this is you gotta give us credit for that, because that's not usable for whatever purpose that the town may need. One of the other criteria could be that the land has to provide a linkage between two existing facilities or future development. That sort of criteria could also be included and in the overall credit review. One other item that we have put into the administrative manual for criteria is who's going to maintain a let's say piece of land that is that's for future widening of a road, and that could be also included in a type of agreement that that piece of land or that 20 feet, let's say right away, needs to be managed by the developer for the next whatever 5 years, 10 years, and so that is another criteria that could be discussed and agreed by the developer and the town. There is amount of credit, the issues. The statute is very clear about the amount of credit, and then that is the amount of credit should not be more than the fair market value of a property or equal to the cost of completed system improvements. So there was construction costs and any other improvements. And I want to discuss this, and Denny, feel free to talk about this. This is a very broad sense, so a developer may include variety of types of things that could be incorporated, but are my sense is that if there is a landscaping done for aesthetic purposes, that is not going to expand. That would not be eligible for that. You want to add any other thing, Denny, in terms of what specific elements that could go into these potential credit amount?
Well, the normal typical stuff would just be the paving and the drainage and such, but something odd that might be included perhaps, and we'll have to consult with Adam about it. But for instance, if part of their drainage system includes a rain garden as part of the road drainage, then that might be eligible as well. So there's a couple of odd things in there. Traffic signals, that type of thing could be included, anything that's associated with the traffic signal. But I don't think street lighting, for instance, would qualify. So it's only those things that are germane to the operation of the roadway. I think that would be the broad criteria.
Okay, yes, and in typically the for a amount of credit or the credit application, it is a developer that makes the proposal and makes and then the town reacts to that proposal, and typically again the cost could also include not only materials but engineering cost and legal costs, if any, and other incidental costs. For example, if there is a survey needs to be done or soil test needs to be done, those are eligible items as a part of this development, as a part of the amount of credit. There are occasions, and I think although Boyer hasn't applied for, but Boyer is a good example that there are certain credits can be awarded in advance, and the development can go ahead and do the improvements before any development or any fee is paid. That's a legal sort of instrument that has to be developed, and that could be part of the agreement that in effect the town is providing the credit to a developer without the developers doing the actual improvements and then later on complete the other improvements for the site.
Tagi, for you and Denny both, how do you know, and Denny, this probably is more in your area of expertise, a developer comes in, has a piece of property, enough for, he's talking like Boyer did, I'm going to put 60,000 square feet of units here. Okay, that was the initial plan before COVID hit. We all know what's going on currently. When the plans are changing in process dramatically, like they've done at 96th project, okay? And that basically is nothing like I'm sure Mr. Boyer imagined. How does one address the fact, what was the initial fee that he would have paid versus what's happening or transpiring 2, 3, and 4 years later, when it was unknown at the time that he brought the development to the table in the first place?
That's a good question, Brian. And how it would be handled is that, again, the fee is paid when the permit is pulled. So if his original plan was to build, say, 100,000, and he ends up only building 60,000, as he builds that, that's what his fee is paid. So he would only pay the fee based on the actual built development.
How do you know up front, or is it an ongoing process? He's paying as he goes, as the buildings or the tenants lease his land and or his square footage. Say he's got 2 lots, 1 and 2, sitting to the north, and he was planning on 15,000 square foot units sitting on that property. Now, if that doesn't happen, or it's not as he planned, say a restaurant or a fast food place, as now we have a Wendy's, how does one compensate if the fee's already been paid up front?
No, it's not paid up front. It's paid when
Okay,
the building
that's
permit is pulled.
for each particular piece of the development. So in other words, when he brings it to town, there is no fee for the initial development.
That's right. As part of
Okay.
the platting approved process, there's no fee paid. We just remember everything is paid when the permit is pulled. So it's the actual land use at that time, the actual square footage at time, and then the under the category that it belongs, and that's how it's paid. So if his plans change, it's a dynamic process because it's paid at the time that the permit is pulled.
Thanks, Denny. Appreciate that.
Sure.
Okay, great. There are some limitations on credit. Again, those limitations include that the developer may only receive credits. And by the way, I notice Adam is back in, so you may want to ask him some question that comes up. The developer may only receive credit for improvements that directly address or mitigate the traffic impact, and this is I suspect that would be a lot of times the developers may pile into a bunch of other stuff that may not be eligible, and there are a lot of improvements may go into the development, let's say a turn lane or even a traffic signal at that entrance that may not be eligible in broader sense for credit or for impact fee credit. You have two items. It either has to mitigate that impact of that development, and the other one would be to basically to add capacity or expand capacity of in the system, in the road system. So if it doesn't do those things, that any improvements that doesn't benefit those sort of two principles then becomes non-eligible. There are another limitations that is clearly identified in the manual that a lot of agencies may require for whatever reason for a developer to provide certain improvements. Plan Commission may do that. INDOT may do that, and but none of those activities, in most cases, would necessarily increase the capacity, and so that is not eligible. Those activities will not be considered or cannot be considered as a part of the credit. This is very important because let me get back to, and I'll get to it in the eligible. That sort of requires that for the town to make sure that what the Plan Commission does is consistent with the overall town's development policies and impact fee policies, and so we don't want to create a situation where a developer is paying double, but it could have been coordinated in a way that it would have been a win-win situation for everybody. That's a sort of good segue to get into eligible improvements. You heard Denny talking about what improvements, what are eligible, but basically any improvements that are identified in the comprehensive plan, in capital improvement plan, zone improvement plan, or other sort of transportation related, road related improvement plan that the town has approved and adopted. Those could be included as eligible activities. In terms of land dedication, uh, those land dedications that are either directly or indirectly mitigate traffic impact of a proposed development or its vicinity. That's important to know that a subdivision goes or a development goes on a particular lot covering half of a block, and the developers may add an additional lane in front, or may expand that additional lane all the way the length of that block. And so that land dedication for the whole length could be eligible and will be subject to credit. In all of the improvements and land dedications, again, must meet the town's objectives as they are determined by the town, and not necessarily by the developer. And also, the one of those other eligible activities is the improvement is or will remedy some of the existing deficiencies or deficiencies that are created by the development. Another item that is we sort of mentioned earlier, and that is, if there is a land dedication, that land dedication is not subject to a mitigation efforts for a subdivision approval process, and so the developer cannot sort of have a double benefits. And but nonetheless, as I mentioned, that if there are subdivisions or plan development that do also provide and benefit to the system in a way that described in A and B above here, in construction of roadways and improvement of land dedication, those could be eligible, and that will have to be handled on a case by case basis. One of the board's process, the most important process, would be this sort of credit approval process. I've developed this chart that shows as of right now, and what is also in the administrative manual, what are the steps a development has to go through, and then how that impacts the credit process. In the process, basically, a developer can come, ask the building and planning to do a fee estimate request, fill out that, and that's a Form 1 that we discussed it last time, and submit that, and the town will do an initial assessment and determine what the fee is. So that fee basically establishes the maximum amount of credit. The developer could accept that and or appeal that process, and the town will then, let's say it is accepted, then the town will review that in a what we call the technical review, and review all of the elements of this credit, and the cost, the land, let's say, dedication, all of the requirements that is typically done. And if I'm looking at the wrong one, so it is after the technical review, the developer is notified, the amount is established, and then that is accepted. If it is accepted, then there is a development agreement that has been put together, and that credit agreement goes to the council, and it is approved. So that is the process for a credit, sort of non-contested credit application. If it is contested, if the developer doesn't agree, then it goes to then it is transferred to the review board. It is forwarded to the review board, and it takes the form of an appeal of that amount, and then there is a process for that. Review board has a process. It has to be put in for public hearing and review, and then at the end, the town will make, or the staff in this case, makes an evaluation of the whole process and makes a recommendation to the review board, and review board will review those, both on the part of the developer's claim, and on the justifications that or findings of the town, and then make a decision as to what that final fee should be. This was yes.
Let me jump in real quick. Between you and Denny, how many appeals have gone forward, to your knowledge, either one of you, for all the other 5 municipalities in the state of Indiana? It was our understanding initially, my understanding initially, there was only one in all the years that it's been in Carmel and Fishers and so on and so forth. Is that to your best of your knowledge, Denny, Tagi, is that the only one that's actually transpired for the years they've had it in place?
I believe it is more than one. And
can you identify, or for me, for us, or I'll do it, and I'd like to be able to know who it was, so that, we might get in touch with them on the phone and just have a general idea of what it involved and how it went.
Mm-hmm. The information that I have is basically coming from online documents that we have reviewed. I can't remember what community, was it Fisher or Carmel? There was a Kroger, for example, grocery store, that part of that appeal process involved a gas stations and number of pumps that they had, I believe, and there was a study done. You are correct; it is not going to be too many, because it is extensive, and most developers want to work out whatever it is with the town to come up with a credit agreement, and especially if that credit agreement has to approve by the town council. But nonetheless, they have that option. And I don't know if Adam is aware of any cases that may have gone beyond that, but it is not that many.
Thank you. Thank you.
So this is the sort of the appeal process. I mean, the credit approval process. As I mentioned, in most cases, that is not going to happen beyond the step of credit agreement. And but if it does, then that's the process the review board will have to do. Now, if it does get to the appeal, there is a form that we have established. You have received it, and so a developer would have will have to file an appeal petition, and that is that is involved. It has to provide a variety of types of information, the basis for that appeal, and the documentation. Basically, either objecting to what the town has made a determination, or not accepting, the fee that has been assessed. In many cases, this is probably more often than the credit application appeal. In many cases, new development comes in, and a fee is assessed, and then that new development feels that assessment of that fee, you recall when Denny was talking about identifying the right code for a land use. They may feel that their development was not identified with the right code, and therefore they're going to appeal that decision. That is more often done than the credit. And that is natural. That is a unique development comes in, or a unique use comes in, and says, no way I'm going to have this many traffic as assessed by the town, and and then they appeal that process. For them to appeal, they basically have to provide the documentation, provide the necessary studies that we talked about earlier, sort of alternative impact fee study. And these are done typically by traffic engineers, determine what that use reasonably could generate, and in terms of traffic, and then calculate a new fee. And they can argue their case in front of the review board and say this should be the fee rather than the other one. One example that comes to my mind was a medical establishment, and again I can't remember in which community, that basically the entity questioned that use of the ITE code for the number of trips, and they had done their own study, and based on their own analysis determined that the number of trips was much less than what was determined through the assessment. And it went through that review board, and it was approved. And so there are many occasions that a development could appeal their case, and if they do, this is what the process they have to go through. Again, for that process, they come in, they do a fee estimate, and there is an initial assessment, and developer then file for or submit for a petition, and there is a process that we have established, and it is established also by the statute in terms of number of days and how fast the board needs to address these issues or address their petition. And but nonetheless, it is this process is that you see here is expected to be followed, and once it is approved by the board, then a building permit can be issued, or a building permit will be the amount of fee that a fee payer may have paid may have to be adjusted.
Tagi, yeah, this is Adam Decker. Good morning.
Good morning.
Yeah, I want to make sure that we're clear on this. The statute prohibits the town from denying issuance of the building permit on the basis that an impact fee has not been paid, or as a condition, or to condition it on issuance of the permit on the payment of the impact fee. And the statute also says that if a petition for review is filed, the impact fee is not due and payable until after the petition or appeal is finally adjudicated. So in your sheet there on this page, where it suggests that the building permit would be issued only after the appeal process has concluded, I think it needs to be revised to reflect the fact that the building permit has to be issued. The town cannot deny the building permit simply based on the fact that an appeal has been filed.
Yeah, I don't know specifically where it is right now, but you're absolutely correct. Yes. Thank you. Well, I think that is the end of our presentation, and this is a good segue for Adam to jump in. And basically, for primary role for the review board is to look at these appeals. And one of the other items that we will discuss next week is to review the administrative manual. And there are several items that we would like to get your input and direction for the manual, that we will then have to revise it or modify it based on those inputs that we received. One other item I want to let the review board to know that there is only one review board for the town, but the town also has a parks impact fee. So although we have talked all about road impact fee, you are also responsible for parks impact fee if there is an appeal in that program. The parks impact fee has been on the books, and we just updated it last year for the town, and has been there for 20 years. There has not been any appeals or any credit requests by the parks impact fee, but I thought I let you know that you are there. So that brings us to the authority and responsibility, and I thought that I asked Adam to give you a review of these. These are all what you see. These are all the state statute in terms of your roles and responsibility. And Adam has graciously accepted that, being volunteer to provide you with additional explanation. And I think it is. Please feel free to ask questions about these from Adam because I certainly cannot answer it. Adam, would you like to start on it?
Yes, Tagi. So, as you see, the state statute requires that we have the review board, and the review board is authorized to review the amount of the impact fee, the amount of any refund, and also to review a credit application if the town and the developer are unable to reach agreement on the amount of the credit. And so this is set forth in the statute, which is cited by Tagi there. There's a process by which the review would be initiated. And so essentially, anytime there's a review sought, the developer must file the petition for review within 30 days after issuance of the building permit for which the impact fee is assessed. So there's a time limit of 30 days within which the developer can file the application for review. And then after that application has been submitted, as again in prior slides, it would be reviewed by the town, most likely by the town's consulting engineer, and then the town would submit its response, a formal response, which would be on a response form. And once that's been completed, and that also provides for a 30-day period for the town to do that, then there would be a hearing held, at which time the impact fee review board would review both the appeal, the petition for review and the appeal, as well as the town's response form. And is indicated in the slide number 2, at that hearing, both parties may appear and present evidence in person by agent or by attorney. So in a sense, it almost becomes an administrative proceeding whereby you, the members of the review board, would sit almost as if you were administrative judges to hear the evidence being presented by both sides. And the board has authority to reverse, affirm, modify, or otherwise establish the amount of the fee, a credit, a refund, or any combination of those matters. And so essentially, in making that review, the review would be completed, and state law does require that the board shall decide the matter at the hearing at which it's first presented, or at the conclusion of any subsequent meeting if that initial hearing is continued for any reason. And then within 5 working days, which is 5 business days after the decision, the board is required to provide a written copy of the decision to the unit and to the developer involved in the appeal. So that's just basically kind of the broad stroke of broad brush of how that process will occur.
This is Scott. Appreciate the information. I guess I have 2 questions on that. Number 1, how much time do we have, or ahead of time do we have, to get familiar with both sides if an appeal does come forward? And 2, do we have any resources to tap into to review numbers, or do we accept numbers and the analyses and what have you at their face value and go from there?
This is Adam Decker. So to answer your second question, as far as what you can review, there's nothing in the state statute or the ordinance that really directs or prescribes what resources you can rely upon in ultimately considering the positions of the developer and the town in rendering a decision. I think because the statute does require, for example, that there be one engineer as a member and that there be one certified public accountant and that there be one real estate agent. I think the statute, again, this was created about 30 years ago, intended that you bring in professionals with these different backgrounds who can all bring their own expertise to bear on the issue that's been presented, on the appeal or the credit application. To answer the first question, the way the ordinance is written is such that when an appeal is filed, a petition to review, and it's presented to the town, at that time, there would be a hearing date coordinated with the members of the Impact Fee Review Board and the town manager and the director of building and planning, which would be held anywhere between 35 and 55 days after the date the petition's received by the town. And that's essentially a time period that sort of builds in the fact that once the petition's been filed, the town has 30 days to prepare its response. So conceivably, if a town takes the full 30 days and the hearing were to be held 35 days after the petition was filed, then that would be the shortest window or the opportunity at least to review the town's position in advance of the hearing. But more realistically, I don't know that it would be scheduled for that soon because that window is 35 to 55 days. So I would say, reasonably, you'd have 5 to 25 days after the town has submitted its response to consider both the petition for review and the town's response in advance of the hearing date.
Thank you.
Yeah, I think you also, Scott, that the town does have an engineer or any consultant firm that reviews all of these road improvements, and so you will have a benefit of his analysis or his determinations also in review of these cases. In other towns, we have seen that it is the review could be extensive, or the materials that they submit could be extensive. That the way it is analyzed and submitted, so you will have the benefit of the work of either the town planner as well as the town engineer. And the personnel manual also brings in the potentially the town attorney for as a part of the consultation, and so that those are also all involved or could be involved.
I'm pretty new to this stuff, so I apologize for my ignorance. But would that not be a conflict of interest if we're going to compare the town's numbers with the developer's numbers and approaches, but then rely on the town engineers who may, as I understand it, would have reviewed and put together their approach and numbers in the first place?
I think what Adam said, and Adam, feel free to chime in. You're basically they're independent, and you're comparing two different opinions. Is that right, Adam?
Well, no, so I think the question is, right. So the town's role, the impact fee review board it has to consider itself as an independent body. And, if you want to make the analogy to a courtroom, the impact fee review board is going to sit as the judge. And so you will hear the case and the evidence that's presented by the fee payer, and then you would also consider the response. And at the hearing, both the fee payer will present evidence, and that could be testimony that they might bring in the engineer to testify. And you'll also hear the town's response, and the town may at that time call a witness. Could be the town engineer. It could be someone to testify about the specific circumstances of the development. But right, from my perspective as the attorney, I certainly cannot wear two different hats. As a town attorney, I would be, I guess, considering myself as representing the town if it was filing this response. Either that, or I could take no position on the town's response, and perhaps that would be left to Dave Westland or other counsel to present that argument to the Impact Fee Review Board. And in that case, if I'm simply going to be advising the Impact Fee Review Board, then I'm, as counsel to the Impact Fee Review Board, I can take no position and cannot advocate on behalf of the town during the hearing. So I think that's a very astute observation. But from the Impact Fee Review Board, from your position, you're simply, going to be considered the judge. You're the neutral. You're going to listen, take the evidence as you see it, consider it, and then make a decision.
Thank you.
Any other comments, questions? Okay. Great. We are done with our presentation today. I know there are some other administrative or stuff that you need to go through. I don't know if that's going to happen today or not. Chris may want to chime in, but our next meeting will primarily discuss administrative manual, and we are going to have a quick review. You have received a copy of it, a draft copy of it, I should say, and we're going to quickly review that and get your input in several issues that we would need to get your input, and then hopefully adopt it as your current administrative manual, and then that manual will be, after the adoption, will be forwarded to the town council for their review and approval, and then that would be our work for next time. I don't know when, what time and date would be convenient. And I don't know, I'm going to throw this next 2 Thursdays from today to get out. If that's acceptable to everybody, we can go ahead.
That works for me.
That would be the 26th of August for those that are unsure. 6 to 10.
that okay with you for Tony?
Yeah, that works fine for me. This is a good time.
Okay, great. So that's, everybody else is, okay with
On
that?
your end,
Yeah, that works for us over here.
yep.
Okay, great.
Wait.
And, I'm gonna turn it back to you, Chris. Are you gonna move on the other parts so that we are done? Thank you very much, and I'll, hopefully we'll see you in 2 weeks. Chris is.
So have a great day, guys.
Was
Yeah.
that August
Thanks, Brian.
26th?
Have a good day.
Wait, I'm sorry, guys. Was that August 26th, 10 to 12?
Correct, Scott.
Correct.
All right. All right, we'll catch up then. And Chris, I think we'll be catching up sooner than that here for tomorrow.
Correct.
You're gonna do the drawings
Yes.
for us.
All right, good deal. All right, thanks, everybody.
Okay, thank
Yeah.
you.
Thank you. Have a good day.
You too.